Yes.
Erica Susha.
Nice to meet you.
Nice to meet you.
This is my colleague Alex. Like a K sound.
Test, test. Test, test.
Well, you don't get the swivel chair. I can sit back there.
Oh.
Test, test. Thank you.
Rosita.
Yeah. I get a lot of that with the Rustucky and stuff.
Morning.
flags. For the field for the state of Michigan session. Presiding, all persons having business herein, draw near.
Good morning. Welcome to this session of the Court of Claims. We are here, I'll call the case number. It's case number 24-000011, Northland Family Planning Center versus Dana Nessel et al. We are here on plaintiff's motion for a preliminary injunction. Before we start, can I have the parties or the attorneys for each of the parties put their appearance on the record, please? Morning.
Morning, Your Honor. Eric Vestusha, appearing on behalf of the intervening defendants.
Morning. Okay. Okay. Thank you. Okay, good morning. Before we begin the hearing, is there any preliminary matters that we need to discuss or go over beforehand? Okay, if not, we can begin.
Hi, good morning, Judge Patel. This is the clerk's office. Sorry to interrupt, but
Morning.
I had an out-of-state attorney in the gallery by Zoom.
Okay,
But he's declining the promotion to come in as a panelist, so I'm not sure if he was supposed to appear today.
does he reach out to him, and if he wants to appear as a panelist, let him in. Otherwise, he can just watch in the gallery.
Okay, very good. I'll give him
All
a
right.
call. Thank you.
Thanks. All right.
Good morning, Your Honor.
Morning.
Rabia Muqaddam for the plaintiffs. I plan to address 4 main issues this morning that warrant entry of the requested preliminary injunction. First, the legal standard. Second, to hone in on the compelling interest element of the standard. Third, the non-discrimination provision in the amendment. And fourth, irreparable harm. First, the legal standard here is nothing less than strict scrutiny. We are here today because Michiganders overwhelmingly voted to amend their constitution in 2022 to protect reproductive freedom, including the right to abortion, to the utmost degree under the state constitution. This was a sea change, which rendered the laws challenged here unconstitutional. The defendants responsible for enforcing and implementing the laws agree. Indeed, Dr. Natasha Bagdasarian, the chief medical executive for the state of Michigan, has supplied an affidavit affirming plaintiff's position and key facts. Intervening defendant has asserted that the legal standard here is akin to the intermediate scrutiny that was available under Planned Parenthood versus Casey. This is completely at odds with the plain text of the amendment. Intervening defendant does not contest with facts or argument how the challenge laws survive strict scrutiny, which is plainly the standard. It has thus failed to meaningfully oppose the relief plaintiffs seek. Second, to discuss the compelling interest element specifically, the reproductive freedom for all amendment specifies that the state can assert only one very specific interest as compelling, an interest in the health of the pregnant person consistent with the standard of care for evidence-based medicine, and which does not, consistent with the standard of care for evidence-based medicine, and which does not intrude upon an individual's autonomous decision-making. The immense and entirely uncontested medical consensus is that the challenge laws do not serve patient health in any way and actually undermine it. This is amply reflected in plaintiff's experts' affidavits, and now the affidavit of defendant MDHHS, chief medical executive. If intervening defendant disputes these facts, it could have entered affidavits to show that they are contested or provide contrary facts, but it did not. I'd like to briefly summarize the evidence as to how each of the challenge laws undermines patient health. So turning first to the 24-hour delay here, that law was intended to persuade people to carry to term. It thus directly was intended to intrude on an individual's autonomous decision-making.
What is your evidence for that, or what is your argument for that?
So I would point your honor to particularly the affidavit from Dr. Biggs. Dr. Biggs is one of the preeminent experts in this field. And what she demonstrates is that dozens of studies that have accumulated over the last 2 decades have demonstrated that mandatory waiting periods do not enhance decision-making. They do not make patients more certain. They do not prevent reproductive coercion, and they do not prevent regret. So the theory that was advanced when this law was enacted was that this was necessary to prevent patients from making a decision that would harm them. And the reality is that's not true, as numerous articles have demonstrated over the last 2 decades. What is clear from the research is also that these laws impose significant harm. So they delay abortion care. Abortion care is time sensitive. It increases an incremental risk as time passes. And one of the particularly perverse effects of the law in Michigan is that you need to print out this form to demonstrate that you received some of the mandatory biased counseling 24 hours in advance. Multiple patients a week at the University of Michigan show up and have to make a second visit. 10 patients a month at Plaintiff Northland's facilities have to make 2 trips. So the law not only delays the vast majority of people by extending the time before they must receive an abortion after they have decided to do so, it also actually results in people making 2 trips. And third, because the emergency exception is so narrow, as plaintiff's expert Dr. Loader, who provides family planning at the University of Michigan, has attested, patients who are experiencing premature rupture of membranes, an incredibly dangerous obstetrical complication, are waiting the 24 hours. So we have a law that does not advance patient health, significantly harms people, and as a result, it cannot stand in any way under the strict scrutiny standard. So I'll turn to the mandatory bias counseling. This law was also intended to intrude upon autonomous decision-making. It was designed to persuade and coerce people to carry to term. It is fundamentally at odds with informed consent. As Dr. Spector Baghdadi attests, who is one of the preeminent ethicists in this state, informed consent is an inherently individualized process. To match the evidence-based practice and the standard of care, providers are guided by their ethical principles and the information that is relevant to a patient. And that process must be individualized. In fact, if providers in other areas of medicine fail to provide individualized informed consent, they are failing to abide by the standard of care. And so the mandatory bias counseling on its own, the fact that it merely exists, is a violation of the RFFA. But even beyond that, the information that is within the scheme is incredibly harmful. So some of the information is inaccurate, particularly the fetal development information that often shows fetuses that are more developed than the actual age. Dr. Baghdasarian's affidavit from the chief medical executive also attests to the factual inaccuracy of those materials and also agrees with plaintiffs that these materials are coercive and that they are designed to misrepresent the risks associated with pregnancy. And overall, again, were actually intended to intrude upon individuals' autonomous decision-making. Finally, the provider ban. So I'll start by saying that advanced practice clinicians are right now at the University of Michigan providing the very same medications and procedures they would use to manage early abortions. I think that is enough to show that this law unjustifiably singles out abortion care. APCs in Michigan are qualified to provide that care by their training and experience. And the intervening defendant's assertion that this law is needed to prevent lay people from performing abortions is really at odds with how medicine is regulated generally. So in every other area of medicine in Michigan, an advanced practice clinician looks to their scope of practice and their licensure to determine what care they can provide. And that is how APCs operate in every other area of medicine. And I'll put your honor to Dr. Levi's affidavit, section 3, where she describes the generally applicable law that is governs APCs in Michigan. And so right now, we know that there are APCs qualified, trained to provide this care, and preventing them from doing so is dramatically constricting the availability of abortion. Thus, the provider ban can also not stand under the RFFA. Third, I'll turn to the non-discrimination provision. So the RFFA has this substantive liberty right. It also has an incredibly broad non-discrimination provision, which the intervening defendant all but ignores. That provision prohibits the state categorically from discriminating in the enforcement or protection of the fundamental right to reproductive freedom. This language is incredibly broad. It clearly prohibits at least two things, one of which is that the state cannot single out one form of reproductive choice out of other reproductive choices. So here, these laws were intended to single out abortion for unique regulation at odds with all other pregnancy care and indeed all other forms of medicine. Second, the state cannot impose restrictions that disproportionately harm some groups. And the well-documented reality is that restrictions on abortion fall hardest on people of color and other groups that face barriers to healthcare access generally. Fourth, why an injunction now? A preliminary injunction, importantly, is always directed at preventing irreparable harm. That these laws have been in effect is irrelevant because in 2022, a sea change in the law of Michigan took place. Michiganders voted to enshrine the right to reproductive freedom, including the right to abortion, as fundamental under their state constitution. And since that time, since the time it has been clear that the challenge laws are unconstitutional, there has been irreparable constitutional injury taking place to Michiganders. We had hoped that the legislature would repeal these laws, given that they are clearly unconstitutional, but it failed to do so. And so we are here seeking to prevent that irreparable harm from continuing. And I'll take any of the court's questions.
Yeah, I have a couple. First, do you want to speak at all to the challenge to section 17015A, the
Yes.
anti-coercion provisions?
Certainly. So in our preliminary injunction motion, and in particular, the affidavits of Dr. Biggs and Dr. Spector-Baghdadi, they talk about how the research shows that people who are experiencing reproductive coercion are not benefited by these laws. So when we talk about the mandatory bias counseling, it includes all of the information that is in 15015 and 15A. It is an interoperable scheme. So it describes a whole packet of information that must be provided at multiple stages. And the reproductive coercion counseling is part of that. So in the sense that they are a scheme that rise and fall together, that's one element. But the second thing is that plaintiffs actually have shown how that reproductive coercion screening is harmful for two reasons. One is this imposes a one-size-fits-all, contrary to the individualized informed consent that is actually the standard of care. And so it may be that patients are experiencing reproductive coercion. As Dr. Baghdasarian, the chief medical executive of Michigan, attests, abortion providers already screen for reproductive coercion, and they are trained to provide a whole host of resources that may be necessary. There are also a whole host of laws in Michigan that protect patients who are people generally who are experiencing domestic violence or coercion. So the idea that this subset of patients seeking pregnancy care need this specific law that has no distinction between one type of patient and another to prevent reproductive coercion is simply false. The second is that the research has shown, as Dr. Biggs attests in her affidavit, that people who are experiencing reproductive coercion, in fact, are harmed by these laws. Often, when people are being coerced into having or not having an abortion, they need privacy of their choice. The biggest impact that these laws can have on them, it can force them to disclose or reveal their pregnancy decision to their abuser. And so while failing to advance the interests of patients who might need additional resources, which providers are already providing, it actually significantly harms people who need to keep their choice private. And in addition, patients who are experiencing reproductive coercion in the form of forcing people to have children, the reproductive coercion screening is particularly horrifying because these are people who are coming to have an abortion to distance themselves from a situation that is incredibly violent or coercive. And so the idea that those patients also have to experience this coercion screening is a perfect example about how this one size fits all information as a whole, as a scheme, is violative of the RFFA. Because to survive strict scrutiny under the RFFA, the law has to advance patient health consistent with the standard of care. It is inconsistent with the standard of care to provide any one size fits all information. And it has to not intrude upon an individual's autonomous decision making. And we think that the entire scheme was both intended to do that and has the effect of doing it.
I also have some questions about the issues that were raised in the Attorney General's briefing, as well as Director Hertel's. First, let's talk about the severability provision. Why? I know that your briefing specifically talks about certain sections of the statute. Why shouldn't the severability provision in section 17 apply to save what can be saved, as opposed to declaring the entire statute unconstitutional?
So 2 points, Your Honor.
Leave your argument.
First, severability can only work when there are portions of the statute that can be severed. And the standard in Michigan is that the statute must continue to operate. It must continue to be a functional law. And so one of the things we've highlighted in our reply to the Attorney General is that these subsections that the Attorney General has pulled out don't continue to operate in any reasonable way. So the Attorney General called out, a few subsections. So
I think there were subsections dealing with the provider and the provider's responsibilities, and perhaps MDHHS's responsibilities.
right. So first, MCL 333-17015-11I4 requires MDHHS to draft, develop, and print materials that are used by providers when complying with the mandatory bias counseling. The agency would then be required to create materials or part of the materials to accompany a process that the named defendants concede is unconstitutional. Are they supposed to create some sort of special subset of the materials? Not clear. The next statute that the Attorney General identifies is subsection 5A 2 through 5. These are the requirements imposed on providers when they screen patients for reproductive coercion, which again, the named defendants concede as a whole is unconstitutional. It is impossible to sever these provisions and have a functioning scheme. That's because it all works together. But the second piece is that whenever you are forcing providers to give universal information without regard for patient circumstances, that is at odds with the standard of care, and it intrudes upon a patient's autonomous decision-making. And thus, it is clearly unconstitutional under the RFFA, along with everything else. The reality based on the amendment is that Michiganders said that abortion should be treated no differently than any other healthcare. There are lots of forms of healthcare where patients may be encountered who are experiencing reproductive coercion. Obstetrical care is the obvious comparator. Reproductive coercion takes many forms. One of the things Dr. Biggs talks about is that sometimes abusers force partners to become pregnant and to have children. That is a huge category of people who are experiencing some of the most pernicious forms of coercion. Those patients who go through obstetrical care are not subject to any of these requirements. Indeed, it may be that some providers of obstetrical care are not even universally counseling patients about coercion, other than based on the universally applicable laws that protect Michiganders who are experiencing domestic violence and coercion. There is no reason that abortion should be treated any differently. And especially because, as the providers have attested, and Dr. Bagdasarian has attested, providers of abortion already screen for coercion because it's part of the standard of care for patients who are seeking to terminate a pregnancy. So based on those 2 points, we think it's quite clear that those provisions cannot be severed, practically speaking, but they also shouldn't be severed because they, like all the other components of the scheme, violate the RFFA.
I guess the last question I have is going to Director Hertel's arguments about the enjoyment and what the injunction, the scope of it, and who I would be issuing the injunction against and what the parameters of that would be.
I'll be honest, we're not entirely clear on the basis for this argument. if it was true that this provision MCL 1299 required any single person challenging any health code provision to sue all 83 county attorneys, there might be some precedent for that. We have not come across a single example, but we have come across examples where providers have challenged, well, not providers, but plaintiffs have challenged health regulations against Director Hertel. And people have not sued all 83 county attorneys. And I think it's notable that this is not an argument that appears in the answer that Director Hertel filed last week. And it's certainly not something that raised in the affidavit by Dr. Bagdasarian. So we don't see any reason in history or practice to have had to sue all 83 county attorneys. And MDHHS is named in these statutes 13 times. MDHHS is directed to create the materials, to maintain the website that most patients use to trigger the 24-hour delay. We think it's quite clear they are integral to the operation of the scheme. And I think Dr. Bagdasarian makes clear that there are a number of requirements that apply to them, and many of which require them to do something that she considers inconsistent with patient health, the standard of care, and the RFFA. So we don't think there's really any reasonable dispute that Director Hertel is an appropriate defendant, and that relief against MDHHS is necessary to afford plaintiffs redress.
Plenty of time for rebuttal. Are the people ready to argue?
Your Honor, I would recommend.
Okay. Okay.
Good morning, Your Honor. Kyla Bronco on behalf of the Attorney General.
Morning.
As we stated in our response to the motion for preliminary injunction, the Attorney General does not oppose its entry, but I am here for any questions that the court has.
Okay, so I think going to the last few questions that I asked Ms. McGutham, what about the Attorney General's arguments regarding the scope of this injunction?
Sure, Your Honor. And as you know, the rule with severability is that portions of the statute that can be operable, as counsel said, must remain. There are at least, I would say, 3 provisions of the statute that aren't connected to either the 24-hour law, the mandatory counseling, or the provider ban. So first, going to MCL, our long statute, 17015, and I'm looking at subsection I. Under that subsection, it says, after considering the standards and recommendations of the Joint Commission on Accreditation of Healthcare Organizations and a number of other
Wait,
organizations.
I'm sorry. What was the section again? I just want to be
It's
reading along as you.
11I.
11I.
I
Okay.
apologize.
No, that's okay. Go ahead.
So under that section, essentially what needs to be created is a notice that's posted. No information needs to be communicated from the provider to the patient, but instead there needs to be a notice posted on the door that essentially says coercion to abort is illegal, and here's a hotline number in the event that you are experiencing this condition. We don't think it's connected to any of the unconstitutional provisions, and therefore it would remain operable.
How do you respond to plaintiff's argument that the entire scheme is interconnected? That once you take out the requirements for the informed consent and the parameters of the informed consent, that it doesn't make sense to have this information because this informs what information is available and given.
Your Honor, I disagree. If it would be one thing, there is a number of requirements in this section that are connected to that specifically talk, for example, about what a provider must disclose to a patient when they're giving them that mandatory counseling or 24-hour information. However, the sections we've identified aren't connected to that. Again, so for example, this notice provision, it doesn't deal at all with a provider providing that information to the plaintiff in a personal way. It seems to be that a notice should just be posted on the door. If you go to the next section, 17015A, and specifically I draw your attention to subsections 4 and 5. So under 4, if a patient under the age of 18 discloses to a provider that they're experiencing coercion to abort or have been sexually assaulted, the provider is then required to contact CPS. Again, that doesn't seem to be connected at all to the unconstitutional provisions. And then under subsection 5,
Well, let's look at that one again, because that subsection, if I'm following the same one that you're citing, cites subsection 3 multiple times in each of the sentences in that statute, in that section, right? So explain to me how then it's not interconnected with subsection 3, which is the informed consent part that they are saying is
Absolutely, Your
unconstitutional.
Honor. So under subsection 4, it says if a patient who is under the age of 18 discloses domestic violence or coercion to abort by an individual responsible for the health or welfare of the minor patient, the physician or qualified person assisting the physician shall report that fact to the local Child Protective Services office. So unlike some other provisions in the statute which directly reference.
Are we in, I'm sorry, we're in the coercion statute?
Yes.
Okay, I was in the wrong statute. Okay, so go back to your first one. What was the first statute provision that you are asserting is not connected to?
I will get it right this time.
Sorry, that's okay. I'm my fault too. I'm following
No.
along and was reading the wrong part.
So it's 333.17015. And then we are at 3 and then I. And then underneath that, there is a sub italicized I, A through C.
3, I see A, B, and C under that.
Correct.
Okay, so we're going 3B. Where are we?
This is, I don't know if you have the same printed page that I do. Do you have this version?
I don't. I
Okay.
have the version that was from the intervening defendants briefing.
So 3, and then it's quite a while past 3. And so if you keep going, it's past, for example, the consent form language with all the lines. And then there's F, G, H, and then an I.
Okay,
And so in that section, again, I would just note that it doesn't seem to be at all connected to the 24-hour provision and can be administered if all of that were struck down.
okay.
And then moving on to the coercion section, 17015A.
Mhm.
There, I draw your attention to subsections 4 and 5. And so 4 and 5, again, seem to be able to operate even if you were to strike down 1701511.
Okay. Okay.
Thank you.
And were those the only parts of the statutes that you claim are subject to severability?
Your Honor, I would also note that there is the severability section itself, but those are the 3 that seem to stand out.
Okay,
Thank you.
sounds good. Thank you very much.
Good morning, Your Honor. Christopher Braverman on behalf of Director Brown.
Morning.
As we noted in our response, Director Brown does not take a substantive position on the merits of the constitutional arguments and does not oppose the relief that the plaintiffs are seeking here. Like AG Nessel and Director Hertel, I'm happy to answer any questions the court may have as to Director Brown's position or role in the case.
Okay, I don't think I have any questions for you.
Thank you so much.
Thank you.
Honor,
Good morning.
Daniel Ping on behalf of Director Hertel. In light of the answer that we filed last week, I think speaks for itself. It's consistent with the plaintiff's position as it's to their ultimate constitutional claim. I just want to use my time to reiterate that Director Hertel does remain opposed to the injunction as it would apply to her and her agency as opposed to the state. I think now that the state is a party against whom complete relief can be sought, it would be respectful of the principle of judicial restraint to tailor the injunction to that entity. We were never intending to argue that the plaintiffs needed to name all 83 county attorneys. That was merely a way to illustrate that an injunction as against Director Hertel would ultimately be confusing, and it would actually serve to exacerbate some of the injuries alleged by plaintiffs.
Director Hertel has been sued in her official capacity,
That's right.
correct?
Yes.
So I'm having a little difficulty understanding your argument that somehow an injunction against her in her official capacity is somehow separate and distinct from a more broad, vague injunction that may be issued against the people or the state of Michigan. Can you help clarify that for me a little bit?
Sure. Well, you know, a core premise of our position is that this is an injunction against enforcement. The director has no enforcement authority, but
There are certainly sections that involve the director's implementation.
certainly
So are you drawing a distinction between enforcement and implementation?
I am, Your Honor.
And why would that impact an injunction that I might issue or not issue?
Well, let's consider an example. The statute requires the director to set up this website as a facilitation of the waiting period. If Your Honor issued an injunction with respect to that piece, what would it look like? Would it entail taking down the website? If so, you know, we are all very keyed in to this lawsuit and what's going to come out of today's hearing. But imagine a provider that is trying in good faith to comply with the statute, might not have immediate notice of the injunction. They send their patient to the website, or they post something about it on their own website, sort of passively. You then have a situation where the patient goes to the website and it's not there. So, you know, I think that's going to inject some delay into the process. Ultimately, if the harms alleged by plaintiffs are going to be mitigated by an injunction, it needs to be all encompassing. You know, Director Hertel has nothing to do with the provider ban. And, you know, the fact is that the state is a party here. And I think part of your question might be hinting at the idea of, you know, well, why not just give a blanket injunction against all of the defendants, original three and the intervening defendant. But, you know, frankly, when you can get the relief you're seeking from a more limited injunction, that's the appropriate thing to do. Did that answer your question?
I think so. On that, do you think that your argument changes at all if the injunction, like there is a distinction between being forced to do something and simply having information available, correct? Like invalidating a part of the statute that says that you have to have certain information available and that information has to be given before 24 hours, et cetera. Invalidating that part of would not necessarily put a burden on the director to take the information down, would it? Or do you think that the two can be read? Is that your concern?
That's certainly something Your Honor would have to think about in crafting the injunction. If it is keyed to the statutory obligation, then, you know, that arguably might leave a little bit of ambiguity with respect to what the director is still free to do.
Can you speak a little more broadly about what powers the director has in terms of outside of the context of abortion care or that care? What powers the director has in populating a website and providing information to the public in her role as director of MDHHS?
Yeah, I think you can find a broad statutory summary of those authorities at 333.2221. The director has an affirmative duty to take action to promote the public health. And, you know, under the Constitution, that includes ensuring access to reproductive care, but it could mean all kinds of things. So I think the director does have broad authority, just speaking in the abstract, to, and this is, you know, please take it with a grain of salt. I'm kind of shooting from the hip here, but you know, they can make these publications in furtherance of that statutory duty, provided it is consistent with law. So, you know, if Your Honor reaches a ruling that certain of these actions, which are currently required by the statute, are unconstitutional when undertaken by a state actor, that would constrain the director's authority to do so voluntarily.
I don't have any other questions for you right now. Thank you.
Thank you, Your Honor.
Good morning again, Eric Rastusha, appearing on behalf of the intervening defendant, people of the state of Michigan. And before I begin, I just want to, I guess, one maybe a housekeeping matter regarding Dr. Bagdasarian's affidavit and the answer. The intervening defendant were not prepared to address that. I did read it and I've kind of given it some thought, but nonetheless.
Would you like time to provide a supplemental briefing on that?
Sure, if the court wants to consider that as part of this motion, I think it would be appropriate for the intervening defendant to have an opportunity maybe to file a, I don't know, 5 or 10
Sure.
page supplement.
How much time do you think you would need for that?
2 weeks, is that too much time?
No, I think that works. 2 weeks from today?
Yep.
Okay, we will issue an order
Okay,
allowing that.
all right, and then for my prepared remarks, they run,
Actually, before,
please.
did you want to do a reply to that?
Yes.
Okay, so is it acceptable if I give 2 weeks for you to do a supplement and then a week for you to do a reply? Or anybody else, any other party that wants to do a reply can have that same time as well. And I'm not going to put a page limitation on what you provide to me. I'm just going to say, please be reasonable in what you give me to read.
All right,
Okay?
thank you, Your Honor.
All right, thank you.
All right, so my prepared remarks maybe run about a half hour, and I'm certainly
Time.
more than happy to hear all of your questions because I'm.
I will definitely pepper you with
All
that,
right, well,
Mr.
good.
Rastusha.
Thank you, Your Honor. Well, there are 3 central points I'd like to make this morning in addressing the Reproductive Freedom for All constitutional amendment and the 3 provisions that are issued. And the first is that the Michigan Court of Appeals has already examined Michigan's informed consent law and the waiting period in 1997 in response to a state due process challenge. And it ruled that the laws were reasonably related to ensuring that a woman's right to exercise her right to an abortion is informed, voluntary, and reflective. That's the Mahaffey decision. The laws at issue here are designed to ensure that an individual's right to exercise her fundamental right to reproductive freedom is safe, and that her right to make and affect decisions is knowing, voluntary, and intelligent.
Mr. Rastusha, would you like me to allow you to say your remarks and then do my questions afterwards?
I
Or
want to
do you
do
want
what
me to ask my questions as you go along your argument? I'm fine with either.
I can do is I can give my presentation in full.
Okay, and we'll save the questions for
Yeah.
after. That works.
That works for you, Ron. Thank you.
Yeah.
In other words, I think the design of this law is to protect a patient's autonomy and safety. The first point relates to the Mahaffey decision. The second point is that Michigan's Constitution recreates the legal framework that existed before the Dobbs decision, as provided in Roe and Casey. In fact, one of the central themes of the campaign was restore Roe. The laws here and others like them were affirmed before Dobbs. So this idea that there was this sea change in Michigan law from the pre-Dobbs legal framework, I think, is inconsistent with the constitutional language and also really the themes of the campaign of the supporters of the amendment. And the third is that the plaintiff's almost exclusive reliance on affidavit fails as a matter of law to overcome the presumption of constitutionality accorded to Michigan law, particularly where the central factual claims or those closely allied with them were presented in Mahaffey, and the Michigan Court of Appeals had affirmed the constitutionality of these laws as a matter of law. And then in the Casey case, essentially the same basic factual claims were advanced there, and the claims ultimately failed, and that the Pennsylvania law, very similar to Michigan's, was found to be constitutional. In short, these are really legislative questions. The proper place to bring these points is to the legislature and not to this court. There's a few background principles I'd like to kind of just tick through before getting to more of the merits of the analysis. One is the injunctive standard. Of course, aware of it. I'm going to focus in on the likelihood of success. The second, I just want to reiterate the presumption of constitutionality, because I think the laws, when you hear it and think about it, give it like a first read again, it's surprising how how high the threshold is that the plaintiffs have to meet. It's only when the invalidity appears so clearly as to leave no room for reasonable doubt that it violates some provision of the Constitution that the statute's validity will not be sustained. It's almost like an unreasonable, it's like a, beyond a reasonable doubt standard of a kind. It's a very high threshold. And I think the third background principle I'd like to kind of identify is this is a facial challenge. In fact, I didn't even articulate the standards in my briefing. I did use that Jeremon font, get my 20 pages in. I was really working hard. But the facial challenge standard is, in Michigan, frankly, is a very favorable standard, again, to state law. In fact, if you look at the case law, separate from abortion, but just go to Michigan law, it's, to make a successful facial challenge, the challenger must establish that no set of circumstances exist under which the act would be valid. It's like the Salerno standard, the United States versus Salerno. The fact that the act might operate unconstitutionally under some conceivable set of circumstances is insufficient. Now, the position that we have staked out is that this constitutional amendment recreates the framework that existed pre-Dobbs. So you wouldn't rely on these standards. These standards are much more favorable. Now, if the plaintiffs are right, it seems to me that they are having to address these standards. The position we've staked out is it's the pre-Dobbs framework. It's Casey, and in Casey, it's an easier standard for plaintiffs to meet. So we want to be consistent with the arguments for advancing. We're not trying to, take different standards, inconsistent, and get kind of the best of all worlds. So for a facial challenge, the Slattery decision kind of works through this and cites Casey and says that the plaintiffs bringing a facial challenge must show that the unconstitutionality exists for a large fraction of the women. In fact, if you look at the Slattery decision, it has a concurrence from Judge Bush who kind of notes this incongruity where, the standard usually all applications have to be shown to be unsustainable, but in the abortion arena, it's now we just have to show that it's unconstitutional for a large fraction. I think that's the right standard, but that's because we think that this has recreated the Casey framework for Michigan law. All right, those are the background principles. So then the statutes themselves, 3 provisions: informed consent, 24-hour waiting period, guarantee that a physician performs the abortion. The laws have long-standing, been in place for more than 30 years. So the informed consent, it's designed to provide information to the patient 24 hours in advance of the procedure, so you're able to have accurate information, not gained from the internet, but now from the Department of Health and Human Services. And it's designed to allow it to be downloaded. Really, the statute is geared to enable the patient to make only one trip. Now, they've obviously made the factual point that there are some patients who don't have the opportunity to do that, but the statute itself wants to enable someone to be able to just have the accurate information and be able to review it. And part of the thinking behind this, of course, is to ensure that you have information that's reliable. And then once you have the reliable information, you're able to make your decision, as opposed to getting reliable information for the first time and then having to act immediately. That's kind of the concept underlying it. Because the Section 3 provides this 24-hour in advance, but it can be downloaded. And then Section 6, or I should say subsection 6, these are all subsections. The whole thing is Section 15, and all the individual paragraphs underneath are all subsections. So subsection 6 requires that the physician do this in person. The key elements of the information are the risks of the procedure and the risks of continuing the pregnancy. Also, the coercion protection. In fact, one of the things that counsel for plaintiffs has mentioned, that this is part of the standard of care, is to do this examination for coercion. Well, this is what the department, or I should say the legislature, has done in trying to help and to assist in the exercise of this fundamental right. And the third is the gestational age and an accurate pictorial description of the fetus. The statute in 2 different places says that the information must be medically accurate. And I think that's significant because some of the claims of the affidavits relate to the forms not being accurate. Well, insofar as there are complaints about the forms, that would seem to me to go to the department and its forms needed to be corrected. It's not really a challenge to the statute. That it seems like a distinct claim. The affidavits also confirm the importance of this information. In fact, if you look at Dr. Spector, Bagdady, Specterbagdady, she says, Exhibit 2, paragraph 25, there is a fundamental duty to disclose, at the very least, accurate information about the diagnosis, risks and benefits of the proposed treatment, and reasonable alternatives to the proposed
I'm
treatment.
gonna break my.
Oh, no,
promise
please
to
do.
you.
Thank you.
Like, I think that goes to the informed consent. And one of the cornerstone of plaintiff's argument, at least the way I understand it, is that informed consent needs to be tailored and individualized to the patient. So what is the argument on the other side that you should have this formed formulaic informed consent that is applied to all patients? And what is then the nexus to saying that if it's not there, that in the context of reproductive rights and reproductive care and abortion care, that the providers are not going to be meeting their ethical standards as medical providers and providing informed consent, albeit not in this statutory prescribed way?
Thank you, Ron. I think it goes to one of the critical pieces of these affidavits, is that the providers say, trust us. We give this information. The law and the constitutional protection doesn't protect providers, it protects patients. Now, I know at Northland, I mean, they may be the flagship. You know, I think one of the affidavits that they perform 8,000 of the 30,000 abortions in Michigan each year. They operate by their own statement, and I don't dispute any of this, the highest ethical standards. But there are many abortion providers throughout the state of Michigan. We know, I mean, our department has seen things in the past with some of the providers being of questionable ethical identity, or practice. That's one of the reasons for the Dr. Figueroa. He was notorious. He was so.
I think that kind of dovetails into another argument that I understand with the 20 pages, it's difficult, but it's the discrimination provision of the constitutional amendment. Section 28 now says that the state can't discriminate in the protection or enforcement of this fundamental right. So what about abortion care sets it apart from, say, a Larry Nassar type of situation where you have a provider doing horrific things under the auspices of being a medical provider? Like, why is there a separate standard, and why does that not implicate this section of the constitutional amendment?
Two responses. One is that the way the argument's been advanced has been that there are no other provisions like this in Michigan, and that it discriminates within reproductive care. And so our paramount response is that this Section 15 is modeled after Section 13, which is the breast treatment cancer, which has, I think, 7 provisions, requires the department to prepare a standard form, asks the doctors to provide it, patients have to sign it. Is the concern, I think, underlying the statute was that women were having radical mastectomies. It wasn't clear that they were necessary. So arguably, if you're talking about postpartum care, this relates in part to the ability to care for children. So there's already a statute out there which really hasn't been addressed that was a precursor to this. And in fact, it's within the same scheme that goes, Section 13, then 15. So the first answer is this is not alone. And then the second part of this answer is this is also, I think, in terms of being discriminatory. It seems to me discrimination is where you engaged in a distinction that essentially tries to draw down or make or burden or enact an improper way in some fashion. One of the things underlying that listing of reproductive freedom, because we're talking really, and the whole conversation here has been about abortion, but of course in that listing also includes childbirth. And in some circumstances, if I have bad information about for reproductive freedom and obtain an abortion because I didn't get good information about what other alternatives or even the nature of the procedure itself, the nature of the fetus, I may have made a different decision. Well, that impinges, or it could affect my ability to exercise my right to childbirth. The legislature, in a way, has identified this as an important thing in the way that Michigan's Constitution has reproductive freedom placed in this Constitution. And part of the driving force, I think it's no dispute that abortion and the decision in Dobbs is what drove it, not contraception and other things within. So that the childbirth and abortion dynamic is really different in kind than other kinds of reproductive freedom, insofar as they may be intention. So this idea that it discriminates or creates some unfairness or casts a negative doubt on it, it's not at all that. It's ensuring that the patients have the best information. The very things that the Dr. Biggs said every patient should have, now the legislature has said, it's not just because you have an ethical obligation, it's because you have a statutory duty.
So
And
your
when-
argument is that I should, in interpreting the language of this constitutional amendment, I should interpret the phrase discrimination as some sort of lowering or some sort of negative impact, as opposed to just a disparate treatment.
Yes, I think that's right. I think that's right. Like, let's say the legislature came in and decided it was going to fund abortion. You know, that we're going to pay for people's abortions. We're not going to pay for people's contraception. Well, I don't think people will come in and say, no, we can't. No different treatment between the different categories of fundamental rights that have been listed in the reproductive freedom. It's where if they took an action that was different in kind, I think it's the idea different in kind that is trying to limit. Like in my view, a statute that says we don't pay for any of these procedures is not unconstitutional because there's no duty of the state. It doesn't burden and doesn't infringe. But I don't think you have a problem where the legislatures come in to ensure that the right to effectuate the decision is then informed, knowing, reflective. I think that's the language of the Mahaffey decision. In a way, all of the affidavits are fighting with the very description that Mahaffey provided about these laws. And I should
Interrupt you again.
Please
Since you
do.
brought up Mahaffey.
No,
we
that's
may as
right,
well
please do.
talk about Mahaffey now.
sure.
So I have a couple of questions that I would about your reliance on Mahaffey and such heavy reliance on Mahaffey, because one of the things that the decision states is that there's a policy of the state to prescribe abortion, and that has changed.
Oh yeah, you are exactly right. The issue in Mahaffey was about whether Michigan's Constitution provided protection for abortion. And then that was the whole analysis. In fact, Judge Murphy had found there would be a constitutional right. In fact, it was like a precursor to the entire litigation that occurred in 2022, really. It's almost like a very similar kind of framework of analysis. But separate from that analysis, there was then its own section. In a way, I think the analogy is this. If we had a statutory construction argument and there was a claim about one part of a law about how it would affect a certain category of people, and if the Court of Appeals said, here's what the law means, this standard of what the law means didn't affect this category, but other categories. If I had a second category of people who come in and say, well, wait, we have a different claim, we think this means something different, the answer would be, well, no, the court's already stated the proper understanding, construction of the law. The very things that have been said this morning by the plaintiff's counsel about it being designed to discourage women from ending their abortions, or it's designed to create delays, increase costs. The Michigan Court of Appeals in the state due process challenge said to the contrary, that it is rather reasonably related to the objectives of ensuring that it's informed,
And that
voluntary,
goes to the
and
reason,
reflective.
I tend to agree with you in terms of not, like the opinion had three parts, and maybe the first part that talked about the public policy in the Michigan Constitution, I don't have to look at that. But I do need to look at the part that you're relying on, which is about these restrictions. And the Mahaffey decision says that the provisions of the informed consent law are reasonably related to the to the achievement of these objectives. So you've got a standard of reasonable relationship. And I think that they relied specifically on Casey, which goes to, I guess, dovetails into your argument that the constitutional amendment is simply a resurrection of Roe and its progeny, which includes Casey. Let's talk about Casey, because I don't know that I read the standard in Casey of undue burden as the same as the strict scrutiny standard that is in the constitutional amendment.
I'm glad you asked that. Can I do one footnote to a prior statement I made earlier?
Sure.
And that is that you had asked about the one size fits all, or making the point about it being this kind of general thing. The department doesn't limit what information can be provided. It creates a floor. In other words, it creates a minimum. And then in fact, in a way, it even invites an individualization of that information. Like if you look at section 15, subsection 11B4, it talks about how the information describing the risks. Want to find this? If you want to read along with me, I don't.
Sure.
All right. It's it's kind of a long statute, but it's 11, and then B, and then it's little 4, the IV.
11B4. Okay,
Yeah.
got it.
And it says, and so the first word in this is state, but of course what they're talking about is what the written summaries, what the department should do with the written summaries. State that not all of the complications listed in subparagraph 2 may pertain to that particular patient, and refer the patient to the patient's physician for more personalized information. In other words, it's almost like we're helping doctors. Now, the doctors, obviously the ones who have prepared these affidavits don't feel helped by this. But the concept though is that this provides kind of like a core set of information that every person should have. And I think too, that if you look at what Dr. Biggs said in one of, she was talking about the fact that, referring to a study in which 750 people across 50 states had used online searches in accessing abortion. I mean, my thought is, boy, that just cuts the opposite way. You have all of these people looking for abortion opportunities and information about abortion on the internet. And my thought is, boy, is that the place where you want to go to get accurate information about these things? Now, I think the internet has a lot of good information, but also it's a mixed picture. So part of what's designed here is we trust the Department of Health and Human Services to provide accurate information. And insofar as it's not medically accurate, let's fix it if there are things they can identify. And then also in that same study that Dr. Biggs cited, and this is paragraph 12 of Exhibit 1, she noted that of the 75% who reported to 750 people, half had gone forward with abortions and half after 4 weeks had not. It underscores the point that the people who are in the position of contacting abortion providers are still in a position of discernment. So having accurate information given to them and then providing an opportunity for them to consider the accurate information seems to me that it fits perfectly consistent with Dr. Biggs' description of what's happening on the ground with respect to patients looking for information and making decisions. Like it seems to me that, thinking of the circumstance about this interplay between abortion and childbirth, the person who comes in is seeking an abortion and finds out they're having twins. Maybe that's a pivotal fact for them. But the idea of not providing information to people so they make decisions unaware doesn't ultimately advance reproductive freedom, because freedom is ultimately runs to the patient. We want to make sure the patients have the information. We refer to these as restrictions. That's not the concept the legislature thought. They don't think of them as restrictions. They're supposed to be empowering, because knowledge and accurate information on which to make such important and irrevocable decisions are supposed to enable the proper exercise of these rights. In the same way that the breast treatment wasn't supposed to burden patients, it was supposed to help them so they have accurate information so they don't get necessarily pushed into a surgical procedure which is irrevocable, which may affect their physical appearance, and also, I think for the purposes of this argument, also affect perhaps even their reproductive freedom insofar as their if they may not be able to nurse, right? If they have radical surgery. Anyway, that's all on the side. I want to come back to the individualization, but you had asked about Mahaffey. and I detoured this footnote, I can't remember now.
Casey,
Casey, all right.
Casey.
So Casey, the standard of undue burden, I think that was the central piece of the argument that I view, because in a way, and I feel bad for the court because, we're a lot of law and the plaintiffs had a lot of facts. And the amount of interchange between our arguments were, the overlap was not as broad as perhaps the court might have liked. And I felt bad about that, but
If either of you feel, or either of the parties feel like that needs to be expounded upon in your supplemental briefing, I am happy to have that. And again, I will rely on reasonableness to be the limiting factor of how long these briefs should be.
okay. So in other words, for this 14-day supplement, we have an opportunity to address Bagdasarian, but maybe make a few additional points, because I did feel like I was kind of
I
shoving
understand
stuff
that.
in.
And yeah, I'm not going to restrict it to, I'll restrict it to the issues that have been raised in the preliminary injunction motion and
Sure.
response. And so the supplement can go to addressing Dr. Bagdasarian's affidavit and any other issues that have cropped up in this hearing, because I'd rather have more briefing and plenary review in making this decision.
That's perfect, Ron. Thank you. So going back to this, so the concept they were suggesting to us is like, you're reading into the statute. It says burden and you said undue burden. And that's kind of the step, and the kind of the preparatory piece to that is, it seems to me that the plaintiffs haven't fully grappled with the fact that this is like a two-part test. There's a threshold inquiry, and once you get past the threshold inquiry, then you get to the compelling interest. This is not a statute that said anything that affects abortion is subject to strict scrutiny. In fact, they put that HFA, the House Fiscal Analysis, in, and it said under the Roe standard before it had been modified in Casey, any law affecting a fundamental right must further a compelling government interest. Any law.
Well, I'm going to stop you there
Sure.
because, it's a new amendment and I need to give fidelity to the words in the amendment. And the first part talks about an individual has a fundamental right to reproductive freedom, which entails, et cetera. And then the next paragraph is, an individual's right to reproductive freedom shall not be denied, burdened, or infringed upon unless justified by compelling state interest, achieved by the least restrictive means. So how does that provision fit into this two-step analysis that you're
the question of where do you have, where is the duty to have a compelling interest is where the right has been denied, burdened, or infringed upon. That's my reading of this. In other words, because I'm thinking this came in the context of Casey. And if you look at Justice O'Connor's opinion in Akron, and that was a precursor to Casey. In fact, even when she was a dissent, if Akron came out the opposite way of Casey, she talks about this very thing. She talks about this two-step inquiry. The threshold inquiry being, it's almost like they were reading her dissent in Akron when I wrote this. The undue burden required in the abortion cases, it says undue burden, but listen, reading past that for the moment. The undue burden required in the abortion cases represents the required threshold inquiry that must be conducted before this court can require a state to justify its legislative actions under the exacting compelling state interest standard. In other words, it's a 1-2. And then she says in that same opinion, we apply strict judicial scrutiny only when the legislation may be said to have deprived, infringed, or interfered with the right. Deprived, infringed, and interfered. It's almost like, hey, we'll take infringe, we'll keep infringe, we'll replace deprived with deny, we'll make interfere burden. I mean, it's the same thing. I mean, this is exactly the same kind
So
of.
say that I agree with you that they have to make that initial showing. And I think that they've attached affidavits from some pretty compelling experts making at least that prima facie argument at this stage of the proceedings. I want to talk about the legal standard because I don't know that I agree with you that the case that this constitutional amendment takes us back to Casey, that the two are equivalent, because, and I would appreciate clarification from you on that.
In my view, that's why in a way I was thinking, in fact, I even came into this argument thinking we should probably ask for additional briefing because that is the threshold question. I mean, I've said, the argument here is the affidavits fail as a matter of law. And we haven't, provided contrary affidavits because we thought if we're right on our legal theory, there would be no need to do that. If we're right that this is a codification of Casey and they were brought,
But Casey, the undue burden analysis or test that was developed in Casey, at least from my reading of the case, was developed because the state had two compelling interests, right? They had the woman's due process, privacy, liberty interest at issue, and then they had the identified interest in the potential for life. And bless you, that's okay. I'm not sure I remember what I said. I don't know that I remember what I said. All right, I will just continue. So
Maybe the court said the potential.
yeah, potential life of potential life, an interest in potential for life. And the test that was developed in Casey was based on the confluence and tension between these two compelling interests. I now have a constitutional amendment in front of me that very explicitly tells me what I can consider a compelling state interest. And it only it's the limited purpose of protecting the health of an individual seeking care, consistent with accepted clinical standards. So given that analytical framework, how does that square with your argument that this constitutional amendment is a codification, so to speak,
Well,
of Casey?
and I guess I should create the proper distinctions, which is, I think it's largely a codification, but it's not an exact replication. And I say that in that, like the post-viability piece talks about mental health. And my thought, that's probably an expansion beyond what was the Roe and Casey framework. But the most difficult part of this Constitution to know what it's accomplishing is the initial threshold inquiry, in my view, which is burden, deny, infringe. So I am suggesting to the court taking Casey to inform its analysis. Casey is different. Casey doesn't, you're all right, it doesn't create a compelling interest. It replaces the whole framework with undue burden. In a way, that's why I've suggested Akron.
But in the analysis of Casey, I feel like the court went through, at least the majority plurality did, in terms of analyzing that. Yes, it recognized that these were restrictions, but it felt that they weren't undue restrictions because they didn't unduly burden the right to an abortion.
Let me fight with you on that.
Okay.
And you can disagree. I mean, for me, this is the nub of the argument. It seems to me what you're talking about right now. I mean, I'd have some other things to say, but I think you're at the heart of the thing. In Casey, step back. In my view, from the plain language, deny, burden, or infringe, each includes like a negative element. You wouldn't say, well, we ensured that your decision, fundamental right was intelligent, voluntary, and reflective, and so we infringed on you would never. It's hard to say that the statute did this and it also infringed, or also denied, or also burdened. In other words, those verbs have a negative element of suggestion of impropriety or a violation. And so let me continue on this theme and draw this into Casey. I think that's the plain language. The question is any delay, any increase in cost, any inconvenience going to constitute a burden? And I think no, that Casey provides the insight, which is an undue burden is an unconstitutional burden. It's an improper burden. And part of the analysis was this from Casey, and I think this was the insight for me. And I think our argument really starts with this as one of the fundamental pieces. Otherwise, we're having to demonstrate the compelling interest. Like, for example, one of the points made by the plaintiffs is we didn't say too much about compelling interest. That's because we front-loaded the argument on the threshold piece. But there's more to say about compelling interest too, frankly, right? I mean, if I had 20 more pages, I could say, here's a lot about compelling interest. Well, in any event, here's the point on Casey on this thing. It says, numerous forms of state regulation might have the incidental effect of increasing the cost or decreasing the availability of a medical procedure. Incidental effect. The fact that a law which serves a valid purpose, one not designed to strike at the right itself, has the incidental effect of making it more difficult or more expensive.
So that incidental effect, I think that it's, at least my understanding, the incidental effect survived Casey because Casey premised the analysis of undue burden on this right to have two compelling state interests. And it found that it was okay to provide, I think, what was structural mechanisms by the state to that may burden and that may infringe upon abortion care, but that was okay because it was considered incidental because it was in the furtherance of this other compelling state interest. How does
Right,
that survive?
And I would recast it. I mean,
Okay.
my view of it is, it's not really an improper burden. It's not an unconstitutional burden. It's not if I am providing information to someone so they can make an informed decision about an abortion. And I guess I'll say this too. One of the things, like in section 14 got repealed, right? That did get repealed in 2023. And section 14 had both statements of interest, protect the autonomy of the woman and fetal life. Both things were stated. Now that's been removed. As a predicate though, for these statutes, they are all designed. I think it's a fair reading, particularly if you're giving the benefit of the doubt to Michigan's legislature and not reading it in a negative way, or looking for a bad will, to inform and enable the individual to exercise this right in a knowing and intelligent way. That's the design of the law. And so the question is, sometimes requiring and enabling these things to occur has incidental burdens. Like think about the right to vote.
I know, but I'm coming back to this point because I think that is where my mind is not quite under either understanding the argument or whatnot. But the amendment doesn't say shall not incidentally burden or shall not.
No, I didn't say incidental burden. I said incidental effect.
Well,
That's my language. That's my fault.
Sorry.
I apologize. Yes, sir. Yes.
So the amendment states that shall not be denied, burdened, or infringed. So if I've read through Casey and it talks about the incidental burden on abortion care. So if I'm trying to understand your argument that Casey is, how does this amendment, how does it square with Casey?
In my view, burden, if you look at the dictionary definition, it's load or oppress. Oppress is it's a hard thing to meet, but load, even in load means, I think, I think it was encroach was the word used. Encroach all suggests pushing beyond a legitimate limit. You have done something that's outside of your authority, the burden. When we protect fundamental rights, let's say it's the right to vote, we may say to a person, obtain identification. Bring that identification with you to vote. We've already created, I wouldn't call them hurdles, but incidental effects, things that may have a cost. I have to travel to obtain my identification. It used to be that you had to register to vote before you appeared, and no one thought that that was unconstitutional. Now, I don't complain at all about being same-day registration. I think that's fine, but we weren't constitutionally required to allow same-day registration, even though having to register in advance for someone who can't travel or someone who's homebound, maybe we'd like to do that by mail, but even there's all sorts of processes associated with fundamental rights. Like thinking about just these facilities, there are all sorts of health regulations that govern abortion facilities, and like all medical facilities, and they increase the cost of operating those facilities. The fact that there may be incidental increase in costs that give form to safety protections or to the exercise of a fundamental right doesn't constitute a burden unless it becomes an unconstitutional burden, an improper burden, something that is outside of the lane in which the legislature can operate. And that's why I think it's telling that arguments being advanced here is the suggestion that they're designed to undermine. Now, there's also the argument that it has the effect of undermining. And I think that the evidence, even within the affidavits, can be read perfectly consistent. I mean, if you have 750 people and only half went forward with those abortions, obviously those people are in a position of discernment in making a decision about whether to go forward, and to get accurate information from the Department of Health and Human Services about those procedures, particularly where it's designed to enable you to obtain that information in advance of the procedure itself. That doesn't always happen. I get it, but that's the design. So, I mean, if you think about the turnaways, one of the affidavits, I think it's from the director of Exhibit 4, Dr. Chelian. She said that the 3 facilities perform in paragraph 14, 8,000 abortions a year. She said that there are 10 turnaways a month in paragraph 22, as many as, maybe more. And if you do those numbers, you crunch those numbers, it would suggest that there's 150 turnaways a year, and they're performing 8,000 abortions. I mean, I'm drawing an inference, and maybe there's further clarification. I might be wrong on my factual understanding, but that would be a 2% turnaway rate or second trip rate. I mean, if we're taking the facial challenge standard, and taking seriously this idea that there has to be, no room for reasonable doubt. And those are very high thresholds on legal points in which and the factual claims here are ones in which there has been disagreement in the community about the value. And of course, the question is, it's not the doctor's view of whether these things are valuable, it's the patient's. And it's not just reproductive freedom for abortions, it's also for childbirth. We know that there have been abortion providers in the past that were driven by profit motive. I'm not saying that about Northland. I want to be really careful about that. I'm not trying to cast any aspersions against the medical professionals. They are, leaders in their field, and I don't dispute that. But we know in the past, anyone who worked in the Department of Attorney General knows that there have been low-performing medical professionals in this arena. And the idea that somehow requiring them to provide this information and to make available to patients separate from the doctor this information to empower them so they can make decisions for themselves and not be dependent on some medical providers who are not ethical.
Okay, then sort of, I guess, digging into the arguments, say I agreed with you about the information that is provided with the informed consent, the statutes. Speak to the 24-hour delay.
Well, the concept is you want to prevent the circumstance where it occurs, where you get the right information, you get accurate information for the first time. And I step back. Northland's already said their professionals provide accurate information. And if someone's uncertain, they wouldn't pressure that person to go forward. In a way, it's almost like they're saying, we do what the statute does already. So you don't need the statute. That kind of assurance, this is a fundamental right? We've placed in our Constitution this right. And it's not just for abortion, it's also for childbirth. So sometimes people will get bad information and come in with bad information about it. And of course, it often takes strong personalities to set up an appointment, come to see a doctor. They've set up an appointment to perform something and then you walk away. Some people don't want to do that, right? I mean, this is just kind of common sense. And I think you can draw, when you're looking at facial challenges to statutes, inferences in favor of the law. The idea, if I got accurate information for the first time, I may feel implied pressure to go forward. And the idea of the statute is I can get that information. If the person has the ability, they can get it 24 hours in advance. They can download it. They can bring the form, and they can, my understanding, they could then go and have it be a single trip. But they're able not to be put on the spot when they get the information for the first time. And it's clear to me that the people who are inquiring about this from the affidavits themselves are not all set on one course of action. All right, those for the 375 approximate who didn't go forward, that was only after 4 weeks. Now, maybe those persons decided to have an abortion after that time. I don't know, but it is clear that it is still a discernment process. People make this initial inquiry if you credit the affidavits. So for the 24-hour waiting period, it's not supposed to be, we'll do is we'll decrease the number of abortions by increasing the ability of people to go to the clinics. That's I think the suggestion is that it was a cynical ploy. But when you have a facial challenge, and this is the people's legislature, you accord them not the worst review of their intent, but the best, which is that they're trying to enable patients to put them in the best position to make decisions for themselves and not be dependent on the information provided by the medical provider. Like some of the abortion providers may think the development of the fetus and its gestational age may not be relevant. It wasn't clear to me the affidavits said that was an essential part of the informed consent obligation. But I would think as a Michigan citizen, if I think, boy, every individual has a fundamental right to both childbirth and abortion, I would want them to have that information, because if you are interested in having children and you may not have if you had had more information, you may have made a different decision. That's the question. That's the question. The question is this information that's relevant for exercising your fundamental rights and your freedom? It seems to me that it is. And I think it's hard for me to see that as a fact question. It seems to me
If
that
someone is seeking out, we have this amendment that is very broad in providing reproductive freedom rights, right? For both choosing childbirth and also for choosing abortion care. And if you have a section of the patients who are choosing abortion care, what is the nexus then with providing them pictures of the fetus?
that's the whole point. And that's why I bring up Dr. Biggs in her paragraph 12. She said 750 people did a search saying nearest abortion provider near me. And at the end of that rainbow, or at the end of that process, 375 had abortions. So the way this statute is designed, those women, instead of just going online and looking for who provides abortion, they could go on and find information out about what their current, if they want. The idea that it's the rare person who hasn't already made up, that person's mind, I think that's belied by the affidavits, right? It's only a 50% grouping who went forward. Now,
But why, I guess I still don't, I understand the emotional impact of being provided that information and seeing the depictions of the fetus at different stages of development. But I want to know, what is the medical nexus with the choice of seeking abortion care?
I don't think it's a medical point, ultimately. It's ultimately an autonomy point. I mean, I'm thinking, I don't, when I think about, my background is I was assistant prosecutor in Wayne County. So knowing intelligence and knowing voluntary intelligence really like second nature to me. And, when they do those plea colloquies, they run through all of those questions, right? In a way, there's an analogy about the concept of making sure that people have the essential information so they can exercise their rights in an informed way.
What is your
So it's a
Oh, go ahead.
Oh, no, I
Go
interrupted.
ahead. What is your response to plaintiff's argument, which I believe is that providing these depictions, which they're arguing are not necessarily medically appropriate or medically correct, that providing this imagery itself is passing a sort of value judgment on whether to seek or not seek an abortion or abortion care.
Two things.
And yeah, go ahead.
Two things. One is, as I understand the argument framed by the affidavits, is that some of the depictions were inaccurate if I had fetal abnormality. And that was, in fact, what was the basis of the decision in Mahaffey and the circuit court. Judge Murphy had made that very point. And so the response to that specific thing is that the statute itself, it contemplates that the doctors can individualize, use it as a basis of comparison for information. So if you have where the fetal development doesn't match what would be the ordinary, now it's information to demonstrate the difference. So it's not geared to draw value judgment. It's to provide information. Like, for example, one of the things that was said is that it overstates the risks of abortion. Well, two of the experts in the affidavit said that the maternal death rate for childbirth is 14 times that of abortion. The department says 17 times. I mean, if you really wanted to drill in on this, the department's overstated the risk of maternal deaths in terms of likelihood for childbirth. The idea is there's no value judgment that childbirth is bad because you're 17 times more likely to die. It's just information that you should have before you make this and exercise this fundamental right. So in other words, they're supposed to be value neutral. Information is not supposed to be geared toward an end. It's supposed to enable the decision maker. There's this idea that someone may have made up, that a patient may have come in already made up that patient's mind. But if they had more information and accurate information, they may make a different decision. Boy, if I knew I was 17 times more likely to die, I wouldn't have gone forward with childbirth. That may be the answer. In other words, it's not about, pro-life people, let's make sure people aren't getting abortions. That's not the way you can read this law. It seems to me you have to say, what did the legislature think that's consistent with Michigan's constitution that would make sense? And what's a reasonable understanding of the law? And if it's provide people who are making these decisions with as much information as possible so they can calibrate their own interests. That's kind of that's the vision behind it. And I know I'm talking now a lot. I want to kind of finish my outline and I don't want to keep you.
I mean, maybe
Sure, no, go ahead.
dovetail from that to the ACPs being able to provide abortion care under their.
Right. I was sensitive to that because I know I haven't touched on that at all. If you read the Bricker decision from 1973, the reason I reference it is because that's where there was this delineation made between physicians and non-physicians. And of course, I think in 1973, people were thinking, not other medical professionals, they were thinking laypersons, right? Home remedies, that kind of thing. So this question that there are other possible medical professionals, I mean, the advanced practice clinician, I think I got the acronym right, that they could provide medication abortions. 19 states have it that way. And then another 16 states allow them to perform procedural abortions. And then there may be, obviously there are more than 19 states that protect abortion rights to some extent. So there must be another set of states that are in Michigan's position, which limits it to physicians alone. It certainly creates like the Cadillac standard of ensuring proper medical action. The point being made by the plaintiffs is that it's unnecessary because it increased the cost and reduces availability. But those, in fact, the medical associations they identified with now come out and support ones from 2018. I think the American College for Obstetricians and Gynecologists, I think it was 2021. These things have all happened in the last 6 years. These are fundamentally legislative decisions. So, I mean, the tools you have at your disposal are blunt. Injunction and striking, right? So should APCs be able to perform surgical abortions or procedural abortions? I don't know what the answer to that question is.
What if I say that they should be allowed to provide abortion care that fits within their specialty and board certifications and standard of practice that's already pretty well delineated by the Michigan Public Health Code and the national standards.
You say all that. That has all the feeling of legislative language. I mean, it seems to me that what you would say is.
Yes, legislative language, but we'll go back to what my directive is, which
Sure.
is where we've got this statute and now we have this constitutional amendment, which and the amendment is very explicit and it's unambiguous, right? And it provides that an individual's reproductive freedom shall not be denied, burdened, or infringed upon. And I think that plaintiffs have at least provided a pretty strong argument for why this artificial limitation of only having abortion care provided by physicians in Michigan does infringe upon and burden.
Well, if that's the
abortion care.
conclusion you've drawn, and if we start from there, I still think the question is, how do you craft that? And I mean, if I'm, I like 8.5 and I like, in fact, I think there are some of these claims that have been advanced that really are subject to severance and the ability to sever in a kind of a clean way. I mean, I think that there's been some suggestions that, feelings of guilt, I think it's B3, I remember where it falls within. If you thought that's a statutory provision that really couldn't stand on its own, that's something that could be severed. I don't think it has to be. I think there are women who have regret. And in fact, there was a amicus brief in the United States Supreme Court in June, Medical Services, about a set of women. Setting it aside, severance is certainly something that's available to this court. But on this piece, we're talking about the physician. It seems to me you have to strike don't think it's one, I think it's actually subsection 3, that's the relevant provision that I think it would be an issue, but leaving that aside, it would be then this idea that no longer does it have to be a physician, but it doesn't have to be a medical professional either. Now, the response of the plaintiffs is there are other statutes that govern that. The whole range of what medical care can be provided. But it begs the question about what conclusion should be reached. I mean, there's not unanimity in the states on how this works. There's a whole patchwork. I mean, that's the whole point. I cited the legislative study to the Connecticut legislature from 2022 when it talked about 19 states do it this way and of that 19
I mean, my inquiry, I think I'm less concerned with what other states are doing and how they're doing it. I want to have my focus on this constitutional amendment and how Michigan does it. And I would like to hear your argument about this, the ACP provider issue, focused on this constitutional amendment and what burdens you see in terms of why is the public health code and the standard of practice that licensure requirements, et cetera, why are those not enough parameters to define ACP care?
And now the reason for the reference to other states is I was just thinking that there could be then within the community of states that have strong protection for abortion rights. There's 2 tracks, maybe even a 3rd track. And so it's not clear to me that our other provisions are going to navigate. So the specific issue would be, can APCs perform procedural abortions? In Rhode Island and 2 other states, they cannot, but in 16 other states, they can. So does your decision to issue an injunction, does it answer that question? And let's say our other statutes don't. I don't know. I mean, it seems like that's a very specific question. Now, I don't know the full range of regulatory. In fact, the statutory site, I think, was like a 42 different statutes. And I, to be honest, didn't go through each of those statutes because I thought, I think what the court's discretion is to strike physician or leave it. And my argument is, they should go back to the legislature. This has all arisen in the last 6 years, and I'm sure the legislature may be more than willing to consider and to frame this, but the information that we would need to draw those conclusions, I'm not sure if you said the very thing you said just now, whether it would answer it in an unambiguous way. The thing about statutes, I know what the answer is. Physicians, yes, nobody else. There's other states, these people are in, these people are out for performing these procedures. A thing that points to other provisions which don't address this exactly seems to me creates uncertainty rather than clarity, and maybe less protection rather than more. And I think it also raises the question, if it's for me, if I have someone who's not a medical professional, and it may be less costly. I'm thinking about the Upper Peninsula. It's really a very, it's a huge expanse of territory. I'm sure in the past people have had home remedies that were effective, and I'm not sure about their safety, right? I don't. In fact, I think that's one of the concerns that underlies this, and the reason for the Bricker decision in the first place was those home remedies. People, they can be very dangerous. Anyway, so I know maybe I'm raising too much of like, oh, it's be horrible and unclear. But that's my real concern, is that it creates uncertainty rather than clarity. So this is my, does it have to be the Cadillac of medical professionals? That's not clear to me, but it's something I think is fundamentally a legislative question. But if you don't agree and you're prepared to, the only thing I would counsel, so far as an advocate, is make sure it's, state, we always follow injunctions, right? That's how we operate, but we always want them to be clear. And so if you're going to revisit this, I just want it to be the kind of thing where the Department of Health and Human Services is going to have sufficient guidance to know what actions it's supposed to take.
Right, and a injunction on the ban on ACP provider care wouldn't necessarily turn. I mean, I don't think there's any dispute that abortion care is medical care, right? So the provisions of the public health code and the licensure requirements and scope of practice, all of those things would still apply. It would just increase the scope of what providers could provide this care, physicians, as well as advanced practice clinicians. Is that, am I misunderstanding any part of that?
No, I think what you said, I understand it, and I guess my only hesitation is I don't have the full range of knowledge of the specifics of what kind of regulatory authority and licensure, how that operates. So that's the only, I just kind of plead ignorance with respect to it. I plead ignorance with respect to it. I'm sorry. All right, I was going to go through the affidavits and make some specific points. I started with kind of the Mahaffey point, but because much of what was advanced here was similar to what was advanced in Mahaffey. They had, the point about how the information for the ordinary person and for someone whose fetus is abnormal, they wouldn't match, and that would be burdensome. And then the burdens that related to travel. My point was in Mahaffey, ultimately, when the court resolved the issue of it being reasonably related, they were able to do so as a matter of law in the face of these factual claims. So that's the basis in which I thought, I think that supports this idea that you can reach the conclusions here without having to have contrary facts from other medical experts that would support the basis for the laws, because the conclusion that it enables someone's decision to be voluntary, intelligent, and reflective is one that's inconsistent with many of the factual claims that are advanced by the plaintiffs in their affidavits. Then about the misleading and inaccurate information, they can be tailored was part of the answer. Insofar as the forms themselves can be improved, that's not really a claim against the statute, that's a claim against the department and maybe even mandamus action, frankly, or maybe as applied, but those are things that can be changed without the statute being suspended. I sure I haven't missed anything, and I wanted to touch on some of the patients are subject to coercion. It seems to me that's a very important part of the statute as well, that tries to shield people from being pressured from outside sources. I know that they say it's part of the standard of care, and I understand that, but that again, these are protections that run to the patients and not to the doctors. And the suggestion that we can just trust the medical professionals to do what they're supposed to do, I don't think the law has to be read that way.
What about the statements in the affidavits by the providers and doctors who, I can't remember which one now, but the claim that somehow the statute actually has the opposite effect in terms of coercion and safety, and the fact that because it's not individualized, it actually might be counterproductive to the purpose.
Seems that the statutes can have a design, have it be effective with some groupings, and then have an unintended consequence with others. I don't think that's that seems perfectly plausible to me, right? But I don't see how a statute, because it may have unexpected applications for a facial challenge, to say, if we take the language of Casey, say a large fraction. I mean, there may be unexpected outcomes, but the design here is to ensure the very thing that they do for their standard of care, which is to make sure that people have information about these things so that their autonomy can be shielded and be supported. I think that's what the law is designed. And that's what my thought is. If there's a challenge that they're really wanting to advance, I think that has to be as applied challenge, not one that's facial in nature. I've said almost nothing about the compelling interest. I guess I'll just step back, because in the briefing, they were kind of shorthands, and I was relying in part on things that have already been stated. If it's the case that really what the legislature wants to do, and you got to give them the benefit of the doubt that they're trying to do something perfectly consistent with Michigan's Constitution, they want to ensure that people who are making these decisions that are irrevocable, and obviously there are hot button issues, right? And people feel so strongly about, They want them to have accurate information. The statute itself says medically accurate multiple times. Why is that bad? I mean, the very thing, how else would it be accomplished? I mean, this idea that trust the medical providers, that's not clear why that's such a wise course. I mean, I understand Northland performs maybe a third or a fourth of the abortions in the state of Michigan, but there's another 22,000 abortions being performed by other providers. Is it clear? Is it unambiguous that how else would it be accomplished other than the department providing this information and requiring that the people seeking the medical services are given the information? I don't know how else. I mean, it seems like this is exactly how you would accomplish it, is by in a way it enables, in the same way as a breast cancer treatment statute, it enables the legislature to provide the information that is objective. It's prepared by the department by, I mean, the department's not made up of Republicans or Democrats or, you know, pro-life, pro-choice people. These are civil servants, and that's what they're supposed to be. We're trying, when we come here, I mean, in a way, we're supposed to be citizens of Michigan. You know, we're trying to represent everyone and trying to do the right by them and to give them information so they can exercise their fundamental right. The waiting period itself was designed to enable one trip to the appointment you can download. I'm not sure how else that can be accomplished. I mean, I guess we can provide, you know, facilities where people can print it out and they can travel and not have to pay an expense, so they can print out the document to avoid that second trip. I'm just trying to think of the practicalities of how else these things could be accomplished. It seems to me for the compelling interest, even maybe for the physician alone, that's not, I'll bracket that. I'll leave that to the briefing. But for the other two, it's not clear how else these statutes could be devised, that because the idea that the right be exercised in a knowing, intelligent, with the right, with accurate information, that does seem compelling. I don't know how else it could be accomplished. So I think if you think that it meets one of those three descriptions of infringe, deny, or burden, if you get to compelling, I think that the point about both the time period for consideration and for having information which the experts in this field tell you that patients should have, it is compelling and it does meet that test.
Okay, so just to recap that last argument, that if we're going under the strict scrutiny standard, that is, and we'll leave Casey behind and undue burden it, but if we're just going by the language of the constitutional amendment, that the compelling state interest is that patients should have accurate information before making this decision, and that the 24-hour wait informs that.
It enables patients.
Well, let's use the language of the amendment is narrowly tailored to meet that purpose.
Yes.
Okay.
It's not 72 hours. It's not 48 hours. I mean, that there are other statutes out there across the country that are longer in duration. 24 is the duration. And frankly, the ability to get an appointment with a doctor within 24 hours is, outside of a medical emergency, is pretty rare. At least that's been my experience. But and then of course there's a medical emergency exception already built into the statute itself. Oh, and right. So then we're going to be filing then a supplement addressing the new affidavit and then any additional information that would be responsive to the questions and issues that's arisen from this hearing. 14 days.
Yes. Did you have, let's take a 5-minute break before we do rebuttal, if that is amenable to everyone.
Sure.
Okay.
Thank you, Ron.
Thank you.
All right.
Oh, they're still there, you've been on it? Yeah. Okay. No.
Everyone had a chance to stretch their legs. We- oh. We'll wait a few more minutes. That's okay. Not yet.
Not yet, you know.
Not yet.
Takes a while for them to filter and run through it. But sports will kind of on that one.
You've done a good job of fitting out the Lansing courtroom for bench trials. I don't know that the Detroit courtroom offers the same amenities. It's a Court of Appeals courtroom, so. Yeah.
We're on the record. I felt very casual.
There's no jury, there's no
Right,
inspection.
it's like, well, it's like we're like, oh,
It's a trial.
Yeah.
Just waiting for my deputy to come back. We will recall the case for, oh, sure. Sorry about that. You ready? Okay, we'll recall the case of Northland Family Planning Center versus Dano Nessel et al. 24-000011. Plaintiff's rebuttal.
I will. Apologies. It's the New Yorker in me. First, Your Honor, I'd like to clarify as to the supplemental filings. So to the degree that facts were introduced in the affidavits first time around, we don't think that the plaintiff should get a second bite at the apple to respond to those unless there were factual claims made in this hearing that are on top of those. Is that right?
Because this is a motion on a preliminary injunction, I think that although your point is well made and heard, for my benefit, I would prefer to have more briefing than less. So I understand it's an extraordinary, it's extraordinary, but I'm going to allow them to give me whatever briefing that they feel is necessary to support their position in opposition to the injunction. And at the same token, I will allow you to respond in whatever way that you feel is necessary to. And if you need more than a week to come up with your reply, please do not hesitate to file a motion with the court. And I will be very open to hearing that.
Thank you for clarifying. So first, I was going to address Attorney General Nessel and Director Hertel's arguments. Apologies. So I think we've gone through this pretty extensively, but just to be clear, even if it's a notice or something that is not directly part of the materials, our position is that that is another one-size-fits-all element that must be delivered regardless of personal circumstances. Such a notice is not ever posted or required to be posted in an obstetrical practice, for example. And as we've discussed, reproductive coercion has lots of different forms. The most common form is that abusers seek to force their partners to carriage term in order to tether them. And so it seems particularly perverse that such a notice might be required in the context of abortion, but not those other contexts. So I think the sign is actually a perfect example of why this scheme, which also operates interconnectedly, should be struck in full. And to Director Hertel, it sounds like we are in agreement that plaintiffs do not need to sue 83 county attorneys. But as to the point about enforcement, I don't think I would be doing my job if I didn't seek relief against every state actor who is part of the enforcement or implementation of the law. So when we talk about whether the defendants are proper, I think the question is whether the relief redresses the harms that plaintiffs have alleged. That's the principal contention. And so in order to get full relief, we need that relief against every state actor responsible for the operation of the scheme. So that's our position as to why Director Hertel should be bound by any relief. It's necessary to redress the harm that plaintiffs have alleged. So I'll turn to the intervening defendants' arguments. And I think I'll take this in 3 stages. The first is to address the legal standard. I think we are all in agreement that the language of the amendment is very clear, and it is not what is in Casey. They are quite different. The intervening defendant has identified a whole slew of legal questions and legal standards that are simply no longer applicable here. And I think when this intervening defendant points to restoring Roe, for example, it's important to remember that Casey was a significant watering down of Roe. As Your Honor mentioned, Casey was designed because the court felt that the interest in unborn life was not adequately protected by the strict scrutiny that was available under Roe. What we have here is an amendment that makes clear that the only interest the state has is in the health of the pregnant person, consistent with the standard of care, without intruding upon an individual's autonomous decision-making. And under the undue burden standard, as Your Honor pointed out, the state could burden as long as that burden was not undue. Under the amendment, the state may not at all burden, infringe, or deny. When a fundamental right is implicated, the question is indeed a 2-part test. Does the law infringe the right? Typically, here it's deny, burden, or infringe, so it's even a little bit broader. The question of infringement is not a question of burden or impact. In a law like this that directly targets the form of care, it is quite clear in our position that that type of law, as a matter of law, infringes. So we think that the question of infringement here is actually extremely clear, and it is not necessary to introduce facts as to that reality. It is certainly true that these laws are far more than an incidental burden, the language that the intervening defendant is borrowing from Casey. It is far more than a de minimis burden. These are pretty extreme harms. It's far more than a de minimis burden. So we're not dealing with an incidental or de minimis burden. But the question here is not about the degree of the burden. The question is whether it infringes, denies, or burdens at all. And I think it's quite clear, and if I'm listening correctly, I think the state has acknowledged that these laws do in fact burden, to some degree. And if they burden to some degree, regardless of that degree, we think they infringe.
What is your response to Brother Counsel's argument that it's not so much of an infringement or a burden, but just part of the execution of providing the care and
So I think the relevant distinction that is missing a little bit in their argument is that there is a difference between generally applicable health regulations and regulations that target abortion care. And these laws were intended and do target abortion care for unique treatment. So we think that's actually all you need to know in terms of the non-discrimination piece, but it also emphasizes how these laws infringe, deny, or burden. So the fact that they target abortion is enough to show that they deny, burden, or infringe. But even if the inquiry was more, these laws have such dramatic impacts, we think it is more than clear that we meet the first part of the test, which is deny, burden, or infringe. As to the compelling interest question, to us, that is a question of what is the standard of care, and does the reality of these laws show that they intrude on autonomous decision-making or undermine the standard of care? And it is normal for plaintiffs seeking a preliminary injunction to put in expert affidavits to attest to what is the situation. How do the facts bear out? And to go through the facts a little bit and respond to opposing counsel's arguments. So turning to the 24-hour delay, counsel has asserted that this law is intended to protect autonomous decision-making, empower decision-making. 2 points. The fact is it doesn't. So the preeminent experts who have studied decision-making in the context of abortion, time-sensitive care, the standard of care for abortion and informed consent, they are plaintiffs' experts, and they have attested that the 24-hour delay does not in any way advance an interest in decision-making, preventing regret, or preventing reproductive coercion. Those are the interests that the state can plausibly assert it is advancing here. And the facts are that they do not advance those interests at all. And the law significantly harms people by delaying care. So the standards applicable to abortion are like the standards applicable to plenty of specialized areas of medicine, are unique. The ethical principles and the base material that might inform a neurosurgeon's informed consent might be different from the standards of care that govern abortion providers. For the standard of care for abortion, it is clear that mandatory delays harm people because abortion is time-sensitive healthcare that becomes more expensive, more complex, and increases in incremental risk as time passes. So a delay both doesn't advance the interests the state can plausibly assert, and it significantly harms people. And to the point that counsel is raising about Dr. Biggs, the point that Dr. Biggs makes in paragraph 12 is that the goal of these laws purportedly is to improve decision-making. What the research that Dr. Biggs cites attests is that delays do not improve decision-making. And the question here that the state has raised is this empowering people to make better decisions? And the research shows that it does not. People go to abortion providers, they are fully capable of determining whether they want to go forward with an abortion or whether they don't want to. And throughout opposing counsel's argument, he has asserted that these laws protect decision-making. But the factual reality is that that is false. And to be frank, if opposing counsel can find a qualified researcher who can counter the dozens of studies that have been developed in this area over the last 20 years, I will be shocked, but certainly we will respond to it. My assumption is, and the understanding we have gleaned from the experts, is that there is no reliable scientific evidence to counter the consensus that is reflected in these affidavits. So when we're talking about standard of care, and when the state advances its interest, it must be in line with the standard of care. And I think it's very clear that the 24-hour delay is inconsistent with the standard of care. It is also clearly intended to intrude upon an individual's autonomous decision-making. An autonomous decision-making. So turning to the mandatory biased counseling. Again, intervening defendant has made assertions that this information is accurate, that it is a floor, that it provides or encourages following individualization. But the standard of care is individualized autonomous decision-making. If there is any part of this law that is not individualized, it is inherently contrary to individualized informed consent, which is not just the standard of care, it is also the standard for medical malpractice, for example. So in other areas of medicine, a provider would be subject to ethical discipline if they failed to ethical discipline. If they provided information that was not tailored to the patient's needs. So the fact that it is one size fits all is enough in our view. I will emphasize that intervening defendant has made some assertions about the materials, which are also factually untrue. So for example, the fetal imagery, aside from being coercive, is inaccurate, not just because it doesn't reflect every pregnancy, but because the fetuses are often more developed than an actual fetus. So there are two levels of inaccuracy there. And also with the reproductive coercion materials, including the notice. The question is whether this interferes with individualized informed consent. And we think it's clear that it does. And for that reason, it is both inconsistent with the standard of care and intrudes upon an individual's autonomous decision-making. So finally, turning to the provider ban, I just want to emphasize upfront again that advanced practice clinicians are right now in Michigan, at the University of Michigan, providing medications and procedures that are used in early abortion care for patients with miscarriages. Those techniques identical to what they would be providing for patients seeking an abortion. That is the standard of care in the context of those procedures in the state of Michigan. There is no reason that they should not be permitted to provide the very same care to abortion patients. The state has pointed in its brief to 2 instances where providers were found to not provide appropriate medical care. Those providers were held accountable due to generally applicable malpractice, consumer protection, and other laws. And I'll emphasize that even in the Supreme Court's cases about abortion, so from Casey to Whole Women's Health to June Medical, those states raised the issue of bad providers. And what the court said in Whole Women's Health is that there is no evidence that targeting regulation that burdens abortion care would have any effect on bad actors. Bad actors are held accountable through a host of generally applicable laws that protect qualified healthcare. So I think what is very clear is that these laws deny, burden, or infringe, and they don't need to do so to an extreme extent. They just need to deny, burden, or infringe. The state cannot do any of those things, not to an undue extent, not to any extent. So turning to Mahaffey, there was quite a lot of discussion about that, and I won't rehash all of it. But the key point to me about Mahaffey is, as Your Honor pointed out, Casey and Mahaffey recognized two compelling state interests. One, patient health and autonomy. The other, potential life. And that whole watered down standard was designed because the Supreme Court of the United States felt that the second interest was not accounted for sufficiently under Roe. What we have in the Reproductive Freedom for All Amendment is a very clear strict scrutiny standard. We have infringement, clearly. We have some denial, burden, and infringement. And then we have undisputed medical consensus that these laws are contrary to the standard of care and intrude on autonomous decision-making. One thing that I think speaks to the non-discrimination provision and also the substantive component is the fact that the state cannot point to a single truly comparable treatment of any other form of healthcare in Michigan. Intervening defendant has pointed to 3 extremely narrow statutes that are so incomparable to this scheme, it is to be laughable. 2 of them are 1-line sentences, and one has 8 subsections. 8 subsections? So the reality is that these laws are unmatched by any other form of healthcare, including far more dangerous healthcare. APCs don't provide neurosurgery. There is no law that says APCs cannot provide neurosurgery. They don't do so because of their scope of practice and their medical licensure and the standards of their license. There is no law that says that APCs cannot provide other forms of more dangerous healthcare. What is happening here is really unique treatment of a particular medical procedure. And what the people of the state of Michigan have said, not to be confused with the name of the intervening defendant, is that by a wide margin, the state cannot treat abortion as different from other healthcare, period. The state may, period. What the RFFA stands for is 1, strict scrutiny, but also the reality that abortion should be treated like any other form of healthcare. Actually, to the degree it is treated differently, it should be even more accessible because it is constitutionally protected. Neurosurgery is not a constitutional right. And yet, in that context, we don't have any of these laws. The reality is that they were enacted because of an intention to protect patients from making the wrong decision, a disfavored decision. And now Michiganders have said that the state cannot do that anymore. And so we think it is quite clear that these laws fail constitutional muster. And I'll just mention one other thing about the affidavits. Whatever the presentation that was made in Mahaffey, in the affidavits, you can see decades of literature since 1997 that has accumulated, making clear the medical consensus that these laws do not advance patient health. To the degree there is any similarity in the contentions, it is now even more clear that these laws do not serve patient health. I think that's all I had, unless you have additional questions for me, Your Honor.
I do not. Thank you to all of council for very, very involved and informed argument. Is, I guess, one housekeeping matter about the supplemental briefing, 2 weeks from today for your supplement is sufficient?
Well, you're asking if I got 21.
Let me look at the calendar. I just,
Because I asked for more time, I was trying to get a transcript.
I don't know that a transcript is necessary for,
It helps frame the question before it is asked, the response.
I understand. I'm trying to balance allowing additional briefing with also providing an expeditious decision. So I think I'm going to stick with 2 weeks for the supplemental brief and 1 week for any responsive briefs to the supplement. And I will get an opinion issued as soon as practicable thereafter. All right. Thank you very much.
All right.